morning, ladies and gentlemen. I'm Azim, your host for today's episode of The Lakeside Show. On today's panel, I am joined by my beautiful co-hosts, starting from...
I'm Zerji.
I'm Jacqueline. I'm Ira Alicia.
And I'm Harvis.
On Season 2, Episode 1 today, we'll be discussing Undue Influence.
Well, the main questions of the talk shows today is what exactly does undue influence mean and how is it established in the courts? Undue influence basically refers to a situation when one party exerts an improper influence to another, leading it into an agreement that might not have been entered under normal circumstances. This concept is deeply rooted in ensuring fairness and equity in contractual relationship. In the landmark case of Punsai Turai, 1919, where the Privy Council affirmed the congruence between the Indian contract law and the English law on the subject of undue influence. Similarly, in Tengku Abdullah ibn Sultan Abu Bakar and others' case, Gopal Sri Ram JCA echoes the sentiment that the sections on undue influence in Malaysian contract law aligns with its English counterpart. Hence, this alignment was further emphasized by Edgar Joseph Junior Justice in Saw Guide Bo case in 1989, where he highlighted the importance of English equity principle in addressing undue influence issues in Malaysian courts. In our country, such suits on establishing undue influence are governed under multiple sections of the Contract Act 1950. Giving an example that Section 10 of the Act established that an agreement is only valid when it is made with free consent. Whereas, this definition of free consent, as per Section 13, emphasized consensus ad Adam, meaning a mutual understanding between parties, and without this consent, there can be no agreement and consequently no contract at all. Section 14 subsection B clarifies that consent isn't free when it is induced by undue influence. Moving on, Section 16 provides a comprehensive definition of undue influence, emphasizing the three core elements used to establish undue influence. Namely, the positions of dominance and the use of that positions, and lastly, the unfair advantage gained by the dominance party. Contract forms under undue influence, as per Section 20, are voidable at the discretion of the influenced party. However, if benefit has been derived from such a contract, the court may, based on its judgment, set terms and conditions for setting it aside. And this concept of restitution, as alluded in Section 65 and 66, is at court's discretion. Well, for today's talk shows, let us explain based on the applications to the case studies involving Chandran, Devi, Ford, and the bank, for you all to understand better about what undue influence means and how it is actually established in the court.
In this scenario, Devi and Chandran are a couple. In law of contract, it was stated that it is generally accepted that the relationships between husband and wife do not attract the presumption of undue influence. This concept was reaffirmed in Monville and Stuart, and according to Lord Magneton, spouses are an example of confidential relationships that do not give rise to such presumption. Similarly, in Public Finance and D.B. Rubble, Edgar Joseph cited Dixon's judgment in Yerke and Jones that husband and wife do not fall under the category of special relationship in undue influence. Therefore, it is clear that Devi is unable to bring a case under Section 16(2). As per RHB Bank and Single Fine, the courts held that three requirements must be fulfilled in order for undue influence to exist in situations where presumptions under Section 16(2) do not apply. These requirements reflect the elements set out in Section 16(1), which are that one of the parties must have been in the position to dominate the will of the other party and subsequently use that position to obtain an unfair advantage. Therefore, Devi has to bring her case under Section 16(1) and bear the burden of proving these elements. First, Devi has to prove that Chandran was in a position to dominate her will. In Sago Prasad and National Westminster Bank, it was indicated that whether a person is in a position to dominate the will of another is a question of fact and is up for the courts to decide. The parties involved in Raghunath Prasad were mere lenders and borrowers, and it was held that a lender was not in a position to dominate the borrower's will. However, in this scenario, Chandran and Devi are a couple. Therefore, there is a pre-existing relationship of trust and confidence, which proves that Chandran was in fact in a position of domination. Next, Devi needs to prove that Chandran used a position of domination and obtained an unfair advantage by looking at the substantive unfairness of the contract to establish undue influence, because mere influence is insufficient, as stated by Rick Bigwood. In Ibrahim Musa, it was held that the sale was not one of undervalue. There was no unfair advantage to Ibrahim over the lady, and therefore there was no undue influence. Here, there was no undervalued sale, therefore, prima facie, there was no unfair advantage obtained. However, although Chandran promised to give her a share in the profits of the business, in a case where the business fails, Devi will not just suffer a loss in profit but also the risk of losing her house, as opposed to Chandran, who will only suffer a loss in profit. Thereby, it can be concluded that there is an unfair advantage to Chandran over Devi, and the transaction is one that is unconscionable. Influence is now proven, and the onus of proof shifts to Chandran as per Section 16(3), who now has to rebut the presumption of undue influence. He needs to show that he did not dominate Devi's will and obtain an unfair advantage. The court must be satisfied upon the evidence that the donor was acting independent of any influence from the donee and with full appreciation of what he was doing. Similarly, it was held in Zemet and Hyman that the presumption may be rebutted by showing that the transaction was entered into only after full, free, and informed thought about it. In Inchinoria's case, it was held that independent legal advice is not the only way to rebut the presumption, nor does the fact that the independent advice that was given rebut the presumption unless it be shown that the advice has been taken. This principle was also applied in Chow Apat. This is in line with R&AG, where the private counsel indicated that the existence of legal advice may or may not be a factor. And this also seems to be the position that is accepted by Lord Nichols in Estridge. Here, however, there was no independent legal advice that was given, as the solicitor David met was Chandran's solicitor, who also failed to explain the risk involved in such a transaction. Consequently, the transaction was not a result of the exercise by the plaintiff of full, free, and informed thought. Therefore, Chandran fails to rebut the presumption of undue influence.
The burden of proof now shifts back to Devi to prove whether the bank had constructive notice of the undue influence exerted by Chandran towards Devi. As per Section 3 Civil Law Act 1956, English common law principles can be referred to if there is a lacuna in the law, which is also reinforced by Felberg. The case of Barclay Banks laid down the guidelines for determining the existence of constructive notice. Constructive notice is said to apply in situations where a party lacks knowledge or actual notice of the particular circumstances. Due to being put on inquiry, the party turned a blind eye by failing to make any inquiry or was negligent in the inquiry made. Lord Brown Wilkinson identified a two-stage approach to determine the existence of constructive notice. The first stage is regarding a wife standing surety for her husband's debt. According to Felberg, suppose the transaction is prima facie disadvantageous to the wife and there arises a substantial risk of the husband committing a legal or equitable wrong. In that case, the bank will then be put on inquiry, subsequently allowing the wife to set aside the transaction. The second stage is about the enforceability of the surety's obligation. If undue influence is proven true and the creditor has failed to take reasonable steps to ensure that the surety fully understands the true nature of the transaction, the obligation will then be unenforceable. Creditors will be considered to have taken reasonable steps if they had warned the surety of the potential liability, the risk involved, and suggested the surety to obtain independent legal advice. It also must be noted that these warnings must be done without the presence of the principal debtor. The principal in Barclays was referred to in two Malaysian cases, which are Maybank Finance Berhad and Southern Bank Berhad. These cases quoted Lord Brown's judgment, and I quote, "Where a wife coerced into becoming surety for her husband's debt due to undue influence possesses an equitable claim against him. In certain scenarios, she might also have a claim against the creditor to invalidate the transaction." Here, Alan, the representative from the bank, was put on inquiry due to the transaction being disadvantageous towards Devi as she is not gaining any benefit from the loan. Undue influence has been previously proven, and Devi now has to show that Alan did not take any reasonable steps to ensure she entered the transaction fully aware of the true nature and facts of the transaction. Despite recommending Devi to meet a private solicitor before signing, such a recommendation was made in Chandran's presence. Alan neither warned her of any potential liability nor risk. He only assured that she would do well if she continued with the transaction, which also definitely affected her decision making. Based on the guidelines of the case of Barclays, as per Lord Brown Wilkinson, only stage 1 was satisfied. Therefore, the bank had constructive notice of the third party's undue influence. Royal Bank of Scotland and Eldridge had provided a more detailed guideline in regards to constructive notice. The guidelines clarified how banks are put on inquiry in situations where the relationship between the surety and the debtor is non-commercial, and the role of an independent advisor in explaining the transaction process to the surety. Banks are expected to inquire about the surety on whether she wants to see a solicitor, who in fact must be provided with full financial information regarding the transaction from the bank. There also must be written proof from the solicitor that the nature and practical implications of the transaction have been explained thoroughly to the surety. If the bank suspects any issues of the surety being misled, the solicitor must be informed of such suspicion. And lastly, a face-to-face meeting between the surety and the solicitor should be scheduled if the surety wishes to meet with a solicitor. From here, the solicitor should explain the process and the risks of the transaction in clear but simple terms. The solicitor is expected to explain the consequences, seriousness of the risk, and nature of the documents. It's also the solicitor's responsibility to confirm whether she would like to negotiate further on the terms or to proceed, and also ensure that the decision to sign the document is hers and only hers.
Here, the transaction is between a husband and wife. Therefore, the bank is put on inquiry as the relationship is non-commercial. Secondly, Alan advised Devi to seek her own lawyer before committing. Based on the facts,
Devi did take up advice, but it was with Chandran's lawyer, not her own. Hence, it could not be said that Devi had access to independent legal advice. Alan should have at least informed Chandran's solicitor of the required information, such as the financial information, transaction, and the suspicions he has towards Devi and Chandran. Despite meeting the requirement of having a face-to-face meeting between Devi and the Chandran solicitor, Alan should have at least informed Chandran's solicitor of the required information, such as the financial information, transaction, and the suspicions he has towards Devi and Chandran. Despite meeting the requirement of having a face-to-face meeting between Devi and the Chandran solicitor, the solicitor failed to inform Devi of the seriousness and the consequences of the risk involved, and made sure that Devi wanted to continue the transaction on her own will with true knowledge of facts regarding the transaction. As the bank and solicitor failed to meet these guidelines, it can be concluded that there is constructive notice of undue influence by the bank. Devi now has two options to avoid the security contract. First, she could opt for restitution under Section 20. The agreement between Devi and the bank is voidable at Devi's option, as there was no free consent due to the presence of undue influence. The court will then set aside the contract, restoring both parties back to their original positions. Devi will gain back possession of the house, and the loaned money will be given back to the bank. The second option is restoration as per Section 66. According to the Young Monkin case, Section 66 includes a voidable contract which becomes void by rescission. The bank would have to return Devi's house if it gains possession of it. General bars to remedy the rescission would not apply, as there was no affirmation or undue delay in seeking to rescind the contract. To conclude, the security contract between Devi and the bank can be rescinded at Devi's option, but the loan agreement between Chandran and the bank will remain valid.
We will now be proceeding into Fuad's case under the Malaysian law.
Under Section 20 of the Contract Act, it is stated that a contract is voidable when the consent is caused by undue influence. To rescind the contract, Fuad has to prove that his consent to entering the security contract is unduly influenced by Chandran. Section 16 subsection 1 illustrated that the victim, in this case Fuad, bears the burden to prove three main elements. Chandran was in a position to dominate his will, Chandran used that position, and Chandran obtained an unfair advantage. In the case of Rossi bin Darus and Bristol and West Building Society, it is established that domination of will can be proved by referring to Section 16 subsection 2a. For someone to have a dominant position, the dominant must either have a real or apparent authority over the victims, or there is the existence of a fiduciary relationship between the two parties. Quoting Lord Justice Millett, the distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary. Although they are longtime friends, and Fuad has often sought investment advice from Chandran, it is not strong proof that they have any fiduciary relationship, or that Chandran holds real apparent authority over Fuad. Hence, it is distinguishable that Chandran was not in a position to dominate Fuad's will when he entered the contract. A clear-cut case where there is no undue influence in this case, as the first limb is not fulfilled. Going on the basis that the first limb is proven, Fuad now has to prove that Chandran used that position of domination and obtained an unfair advantage over Fuad. Referring to Bigwood, unfair advantages in contracts are situations where one party takes unfair advantage of a special weakness or vulnerability that they find in the other party. According to the case of Ibrahim bin Musa, it was held that unfair influence is an essential element to be proven by the victim in all the cases of Malaysia in order to establish undue influence. On the facts, there is a distinguishable unfair advantage obtained by Chandran, as Fuad had to risk his public company's shares as a security to the bank. Although Chandran did state that he would share the profit with Fuad, the risk that Fuad had to bear is inconsistent with the benefits that he would possibly obtain. Hence, it is proven that Chandran has obtained an unfair advantage over Fuad. When undue influence is established, the onus probandi shifts to the dominant party, in this case Chandran, by virtue of Section 16 subsection 3 of the Contract Act. The section places the ultimate responsibility on the dominant party to demonstrate that the contract was not a result of undue influence. While the victim Fuad bears the initial burden to present sufficient evidence that the transaction was unconscionable as established in the Saad Marwi case, Chandran must counter this by proving he did not unduly influence Fuad's decision to enter the security contract. The first rebuttal that Chandran can raise is that Fuad had independent legal advice. The bank's in-house lawyer had explained the risks associated with the transaction to Fuad in Chandran's absence. Hence, it can be indicated that there is independent legal advice. While this action might seem to weaken Fuad's claim of undue influence, it's essential to note that this is a merely relevant factor and not a decisive one in rebutting the presumption. As mentioned previously in the case of Inshe Noria, it is held that independent legal advice is not the only way to rebut such presumption.
Therefore, Chandran will most likely succeed in rebuting the presumption of undue influence. Now, the burden of proof shifts back to Fuad to show that the bank had constructive notice of Chandran's undue influence. Using Section 3 of the Civil Law Act again, here the bank is put in inquiry as the transaction was disadvantageous to Fuad. Fuad has to prove that the bank did not take reasonable steps to ensure that he entered into the transaction while being clear on the true nature and facts of the transaction. Here, the bank provided Chandran a lawyer who explained to him carefully the risks involved in such an explanation was done without Chandran's presence. Therefore, the bank here is regarded as having taken reasonable steps. Hence, the security contract between Fuad and the bank remains enforceable.
In conclusions, it is firm that both loans agreements between Chandran's and bank will still remain valid. As for Devi, her security contract with the bank is voidable, and it can be rescinded at Devi's discretion. However, Fuad's security contract with the bank will still remain valid as undue influence can't be proved. The same conclusions would be reached under English positions as well.
That concludes this episode of the Lakeside Show. Thank you for watching and stay tuned.
Okay.